Well, good morning and welcome to World Arbitration Update. This is day 4 of our 2022 conference, and we're starting out today with a fantastic topic, one that has generated a great deal of interest in the international arbitration community, in particular those who are interested in investor-state dispute settlement. And that is this morning's panel, titled Taking Stock of the ECT Modernization Process, with the question, fit for the 21st century? And of course, the Energy Charter Treaty has been a leading instrument in the world of investor-state dispute settlement. We've seen a number of new cases over the last year in the energy field, particularly with respect to renewables. It has resulted in numerous leading cases, and in terms of um, the generation of a lot of new law and new thinking and a lot of controversy. It's been an interesting time the last 3 years under the Energy Charter Treaty, and we have a fantastic panel today. And actually, I should introduce myself. My name is Ian Laird. I'm a partner at Kroll and Mooring in Washington, D.C., and I'm co-chair of World Arbitration Update with my colleague, Dr. Jose Antonio Rivas from X-Strategy LLP. Um, so welcome on behalf of both of us. We have up on the board here a list of our sponsors, and as a first kind of administrative matter, I just wanted to thank our sponsors for their huge support. We couldn't have done it without them, as well as our numerous supporters who are listed on our website. We've had a fantastic uptake and support for World Arbitration Update in this second year. And really, I think a lot of it goes to part of the focus of World Arbitration Update, which is to provide updates to the international arbitration community in an easy to access manner. As you know, this is not a paid conference. We're going to be having a new service shortly to provide access to recordings of our sessions. We really are attempting to support and broaden access to fantastic experts in this field, and I think we really succeeded with that. And this group is a good example. As well, we're trying to respect and as well as reflect the incredible diversity of the international arbitration world. International arbitration now stretches to every corner of the planet in terms of different cultures, legally and otherwise. The international arbitration world has grown incredibly, and we also have set up over the course of the 19 panels over the course of this week an example of that, trying to have panels in different regions covering different topics that are topical to those regions. And we hope to do that in the future. And today's panel is one of our highlights of the conference. This is a really very cutting edge topic. And we have a great group of folks who've agreed to come and speak to all of us today about this topic. And I'm going to pass off to Jose Antonio now, and he is the moderator of this panel. But not only that, he is a very accomplished arbitration practitioner himself. He has a SJD from Georgetown University Law Center here in Washington, D.C. He followed that by becoming a counsel at ICSID for many years, working on some of the leading cases that many of you know, and has now founded his own firm, X-Strategy. And he has an incredible experience, and it's really a privilege to work with Jose Antonio on this conference. I just wanted to say, and on that last final note, that Strategy has LLP, his firm, has really done a fantastic job organizing the conference. You've seen Maria Lucia's name and Anna's. They really have herded the cats, and there's nothing harder than herding cats in the international arbitration community. They've done it masterfully and with grace and with great humor. So thanks to both of them. So on that note, I will pass off to Jose Antonio, and we'll kick off this fantastic early morning panel, at least in DC, on the Energy Charter Treaty. Jose Antonio.
Thank you very much, Ian, and thank you, I couldn't stress more how grateful we are for all the supporting organizations and our sponsors, and it takes. It takes more than a village to put up a conference like this. I know that many have been contributing from from curating the whole program, proposing themes, providing information, etc., recommending speakers. So thank you to everyone who has been involved, and within that group are of course all of our speakers today, including Maureen Carlson and Nikos Lavranos and Lucas Stifter and Daniela Gika-Janou. Thank you very much. I would like to go ahead and introduce them, but before going there, basically, we have been in World Arbitration Update and also in its sister event, the Washington Arbitration Week. We have had a focus every edition, every version. We have had a focus on the development of what are known to be intra-EU cases in investment arbitration, and we have also had a focus on how or the tensions between international law and European regional law, and we have also had a conversation about BITs and in the EU, and some of the cases that have made it to the specialized news because of the challenges that they pose, both for recognition within Europe, as well as for enforcement within Europe and outside. And this year, given that the modernization negotiations were launched during the pandemic, not this year, but last year, we considered that it was a key and newsworthy development, and we had to have that discussion about the consequences and the process and the outcome, and the consequences for investors, etc. So in front of you, we really have a series of individuals, three of them European, and two of us from the Americas, who have really thought and lived that modernization process, either because like in the case of Lucas, he has been part of the modernization process and negotiations, or because they have been closely watched that process as Nikos, because in a past life he was himself a negotiator, or because they were part of the European Commission, like in the case of Daniela, or because like in the case of Maureen, they have had to watch this because of her obligations as counsels and also arbitrator, or like in my case, because of the conference, and also because I have I'm full disclosure, also have clients involved in cases related to intra EU matters. So with that, I would like to put the focus and onus on the speakers and say a few words about them, because it's really worth knowing who we have in front of us. Now, Lucas, I will start with Lucas Stifter. He is a senior investment policy officer with the Austrian Ministry of Labor and Economy, and represents Austria in various European and international on investment treaty issues, such as the EU, the OECD, and UNCITRAL. He has served as chair of the ECT, Energy Charter Treaty Modernization Group, since July 2020. Now, next, we have still in Europe, we have Nikos Lavranos. He is an expert in investment law and arbitration, who has expertise in advising, litigating, negotiating, drafting legislation, and providing expert witness reports. His clients are both investors and states. He combines his experience as arbitrator, mediator, legal consultant, academic, and former policymaker and chief negotiator for bilateral investment treaty. He has a PhD degree from Maastricht University in 2008 and 2009. Nikos was a Max Weber Fellow of the EU in Florence, and he is a permanent contributor to the Kluwer blog, among many other things. We have also with us Maureen Carlson, who has really been an incredible supporter of the new wave of forums, both the World Arbitration Update and Washington Arbitration Week, and has always provided ideas for both forums, and is impressively the co-chair of the Global Arbitration Trade and Advocacy Practice at Sidley Austin. She has focused her practice in investment treaty arbitration for more than 20 years, representing both claimants, investors, and respondent governments, including in ECT cases and bilateral investment treaty cases in the energy sector. Maureen is also an adjunct professor at both George Washington University and American University Law Schools. And last but not least is Daniela, who is a fellow at the Carolla Institute at Georgetown Law School, where she focuses on investment law and policy. She was part of the international arbitration team of a US firm and of a legal services of 2 EU institutions. Daniela specialized in the EU law and international arbitration at College of Europe and Georgetown Law Schools. Welcome for this really impressive panel. And we'll start with Daniela, who will be our presenter in order to update us and everyone on the latest developments, both in ECT modernization. It's more of a contextualization, and also relevant cases of ECT framework. Welcome, Daniela. So you have the floor.
Thank you very much, Antonio, Jose Antonio Rivas. Good morning, good afternoon, and good evening, everyone, depending on where you are located. So I will start with outline a brief presentation of the ECT, because I'm mindful that we have an audience that has different knowledge about the ECT, more expert, but not so expert. So I'll give an overview, then the modernization process, then what's happening with the investment disputes, because we have Lucas, who will tell us more about the modernization process itself and the content and the context. Then the problems with the enforcement, you'll see them as challenges and opportunities. At least from my side, I see them as challenges and opportunities, and I'll explain you why. Now, also the current state of affairs, and I will leave you with a question that is very, very dear to my heart. Next slide, please. So the Energy Charter Treaty, I think we can, yeah. The overview is the Energy Charter Treaty, for those who don't know, it's a multilateral trade and investment treaty, and it has 54 signatures. Signatory parties at the end of June 2022. Also, the European Union and Euratom are part of this treaty, and this treaty is known in the European Union law as mixed agreement. And you'll find there interesting term for those who are not acquainted with the ECT, the Regional Economic Integration Organization. This is basically the European Union. This treaty came in the 90s to promote energy cooperation and energy trade between European states and other energy producers. Now, as the ECT exists, contains provisions covering protection of foreign investment, also non-discrimination rules for trade in energy, the dispute resolution mechanism, the source of all evils these days, between contracting parties and foreign investors and contracting parties, and also the promotion of energy efficiency. Just to give you some numbers, since it entered into force in 1998 until this moment, there were 150 cases and pending 54, and Spain is the one having the record on the cases. So you'll see there on my slide that I put the modernization as a necessity. It came as a necessity because at the moment when it was drafted, the Energy Charter Treaty wasn't aligned with what is today the Paris Agreement. So that's a must today. That was one of the reasons. But also there were some inconsistencies between how the treaty and especially the investment protection clauses, they were interpreted by different arbitral tribunals, national courts, and recently by the Court of Justice of the European Union. And last but not least, the EU's concerns on the investment protection and the ECT. A little timeline there. At the end, you'll see that the negotiations, they started in July, and in 2 years, we had an agreement in principle. A text was leaked, fortunately or unfortunately, in August 2022. So Lucas will tell more about it. That being said, the contracting parties are supposed to meet in November to discuss the latest text and to adopt it. Now, what's happening at the level of the EU? So this is the treaty, and this is how it looks. And we have the members and the observers, and thank you to the Secretariat of the ECT for this comprehensive map. Next slide, please. What's happening at the level of the EU? So there is a problem. There was a problem at the beginning when the treaty was drafted. There was no disconnection clause. For those who are not acquainted with what is a disconnection clause, is the respective clause that basically excludes the application of the ECT in any intra-EU disputes. As I said, the EU and the Euratom are members of the ECT. All the EU member states are members, with one exception until now, Italy, which withdrew in 2015. But the treaty will still apply until 2035 because of the sunset clause. Now, since it's a multilateral treaty and not an intra-EU BIT, one will ask, what's the problem with it? Well, the problem is the investment dispute. So on the left side of the presentation, you'll see some buzzwords, but it started with the intra-EU bids when the EU law was actually, and it is considered having supremacy over any intra-EU, and that comes from an old jurisprudence of the Court of Justice, the principles of primacy of EU law and autonomy of EU law. And for those who are not acquainted with the EU law, because I know that we have people also from the US and other jurisdictions, the primacy of EU law, it's over any conflicting norm, not only national, but also the constitutional norms. And then the autonomy of EU law comes from an old case of the Court of Justice, where the court stated that the European Union law, or the community law back then, is a closed system. So for the member states, EU law, it's a supranational law. And in Comstroy, last year, the European Court of Justice said that yes, the ECT is a multilateral treaty, but when it concerns an intra-EU dispute, it becomes EU law. So for a specific intra-EU dispute between a EU investor and a member state of the European Union, the Court of Justice has the right to interpret it. Then we have also disputes, of course, between non-EU parties or between a EU party and a non-EU party, and that shouldn't be a problem until last year, when Comstroy set the scene that it doesn't matter if you are a non-EU party. If you want to enforce your award in the European Union, that might be a problem, because for those who don't know, Comstroy, and I won't present the actual award or judgment, just to set the scene. Comstroy is a dispute between an Ukrainian investor and the Republic of Moldova. None of them is a EU party. The only EU connection was the seat of arbitration, which was Paris, and the fact that the investor wanted to enforce, and there were annulment proceedings before the French courts. This is how the ECJ got access, let's say, to the award, and had the possibility to interpret and to respond to three preliminary questions from the Cour d'Appel de Paris. And after Comstroy, when the arbitration world and the investment world were still recovering and trying to understand Comstroy, we have PL Holdings. This is not ECT case, but in my opinion, actually, it closes the circle of what's happening in the European Union. This summer, we have the first and the only award, Green Power versus Spain. That's an ECT award where the intra-EU objection was admitted by an arbitral tribunal. In the rest of the 64 cases, there were only rejections, BITs, intra-EU BITs cases, but also ECT. Now, just to mention, if we can move to the next slide, that there are challenges and opportunities in the enforcement side, and one challenge is in the intra-EU, because we have some principles that might come into question if there is a possibility to enforce, and these are the principle of sincere cooperation between the national courts, autonomy and primacy of EU law, and as the Cour de Cassation from Luxembourg in July this year stated, it could not enforce an ICSID award, which is not an ECT award, but is still an ICSID award, because of this principle of sincere cooperation. So now, if we corroborate Mikula with Comstroy, that might be a problem. The opportunity, in my opinion, is about the enforcement outside the EU, and you might see it in the US courts and in the UK courts. In the US courts, we already have some precedent, let's say, if there is an enforcement under the ICSID rules, we can see the Mikula saga. And under the New York Convention, we have Comstroy itself, which was allowed for enforcement last year in December by the District Court for the District of Columbia. In the UK courts, the problem might be, the enforcement might be with a caveat, because, well, the UK Supreme Court after Brexit allowed the enforcement of Mikula, but the European Commission didn't like it. So it started an infringement action. And that being said, Comstroy was rendered after Brexit, which might give food for thought to our audience, if that can be enforced or not. And just last slide on the current state of affairs, we have member states which are not members anymore, Italy. Then we have Poland, which has draft legislation to withdraw. Spain and Netherlands, who announced that they might withdraw, and some latest developments from Germany in Mainstream versus Germany, an ECT case where the High Court of Berlin stated that the German Civil Procedural Code doesn't apply if there is an ECT arbitration, even if there is an intra-EU nature. Whereas the Oberlandesgericht from Cologne said in 2 cases against the Netherlands that actually, because there is a conflict with the intra-EU rules, because there is ACMEA and PL Holding, it doesn't matter if it's an ECT word, the German Civil Procedural Code will apply. And that's my presentation. I leave you with Lucas, and thank you very much.
Thank you very much, Daniela. That was, I believe, a terrific effort of conciseness, given that you are referring to multi-jurisdictional court decisions, and also in parallel to the setting up of the modernization process. Note that the reference to the principles related to EU and primacy of the EU and so on and so forth that you mentioned are all within the world of EU law, not necessarily within the world of strictly of public international law and the Vienna Convention on the Law of Treaties, which of course was not referenced in some of the decisions that you alluded to. With that, I would like to welcome Lucas for comments and his insight, fresh out of the oven, concerning the modernization process of the ECT. Welcome, Lucas.
Thank you very much. Good morning and good afternoon to everyone. First of all, thanks a lot to the organizers for inviting me. This is my first participation in this update event, and doing this as a speaker is, of course, a great honor. Also, big thanks to Daniela for very ably setting the scene, which makes, of course, my job much easier when explaining the reform efforts that were undertaken over the last 2 years. So in my brief overview of what has been discussed and how it has been discussed, I will, of course, more or less scratch the surface, but I look forward to in-depth discussions, maybe also on the basis of the comments provided by Nikos in the course of this panel session. Let me offer a few explanations on the process itself. So as already indicated by Daniela and by Jose, I believe we started negotiations during the pandemic. Everybody was sitting at home, just as I'm doing right now. We had negotiations mainly via Zoom, which meant that we saw each other for the first time in person at some point in 2022. So very, very early before we actually concluded the negotiations. This, of course, did not make life easier. We had to get up here in Europe at least very early, 6 in the morning. But nevertheless, I think the outcome is quite interesting in many respects. Much has been said, mainly from the viewpoint of the European Union, but what has been really at the core of the negotiation was the question to what extent amendments need to be implemented in order to align the ECT with the Paris Agreement. This is, again, a very European discussion, but of course it had an influence on the text proposals that were submitted. Now, on the mobilization group itself, it was more a closed process. No outsiders were allowed, only contracting parties. Documents were not supposed to be made public, but they were leaked, as has been mentioned already in the introduction to this conference panel. And the scope of the negotiations was very focused. We agreed on a so-called list of topics at the outset of the negotiations, which had the following main areas: definitions, investment protection, so the substantive law, ISDS, but only in a very selected manner. So just to make this clear, the establishment of a court, as it is now implemented in new treaty practice, was not on the agenda. Other topics were transit, sustainable development, the question of RIO that has been alluded to by Daniela already, obsolete provisions and pre-investment. In my brief overview on the outcome of the negotiations, I will say a couple of words on the issue of definitions, treaty scope, investor protection, ISDS related provisions, and REO, that is intra-EU application. So when it comes to the treaty scope, when we discuss the definitions, one topic was really at the core of controversial negotiations, and that is the topic of definition of economic activity in the energy sector. Now, why was that important? As most of you will be aware, in order for an investment to be covered by the ECT, it does not only need to fulfill the general requirements under Article 1, Para 6, which are very similar to other investment agreements. It also needs to be related to a so-called economic activity in the energy sector. And in order to qualify as an economic activity in the energy sector, the economic activity must be related to a so-called energy material or product. And what constitutes an energy material product is regulated in an annex. It's a so-called Annex EM1 and EM2. It's a very technically long list of different energy materials products. And as I said, in order to be covered by the treaty, an investment must relate to such an energy material product. Now, the big discussion was to what extent it is still appropriate to have fossil fuel energy materials and products covered. Basically, well, one can say two camps in the discussion emerged, one being led by the European Union, which made their text public, so I'm very comfortable to speak about it, who tabled a proposal that should have been applicable to all contracting parties, which would have led to the exclusion, to the transitional exclusion of investment protection for fossil fuel investments. Then there was another view, another camp, that more or less took the position, we appreciate your demands, we appreciate your concerns, we also signed up for the Paris Agreement, but we just don't see the necessity to go that far. It's a different topic, more or less. So we came to a point where it was clear that there is no consensus on this topic. What we then proposed, and which was finally accepted by the contracting parties, was flexibility, to agree to disagree and make individual flexible solutions for individual needs of different contracting parties. So the result of this discussion is that we introduced a flexibility mechanism by using the so-called Annex NI, that's an existing annex in the Energy Charter Treaty. And on the basis of that annex, individual contracting parties can exclude the application of Part 3, which is the substantive investment law of the ECT, to certain fossil fuel energy materials and products. So far, the European Union, the UK, and to some extent Switzerland have availed themselves of this possibility. Others don't, but it's also a forward-looking solutions. We are using an annex, which means that if further amendments or further exclusions, if you will, should be implemented, you do not need a treaty amendment. It can be brought about on the basis of a simple decision of the ECT conference, which requires unanimity, but still you avoid lengthy ratification procedures in domestic parliaments. Now, looking perhaps at this issue from a broader perspective, it's quite novel, right? So far, investment protection agreements have been based on the idea that any FDI is good, basically, of course, with some exceptions, for example, in accordance with the hosted law clauses, but still there was no distinction between good and bad economic activities that should enjoy the protection of the treaty. Now things in the ECT context are different, and of course it will be interesting to see to what extent this influences state practice, treaty practice in other agreements. Now, moving on with my brief overview of the substantive outcomes of the negotiations. Just a few words on the other investment protection related provisions. So on the definition of investor, we included a substantive business requirement in the home state, including a list of factors that ought to be taken into account in order to establish such substantive business activity. The investment now needs to be made in accordance with host state law. We have clarified fair and equitable treatment. So the, I should say, quite complicated structure of current Article 10 paragraph 1 has been replaced by 2 paragraphs, basically. One paragraph setting out the obligation to accord fair and equitable treatment, the other paragraph providing for a list that specifies situations that constitute a breach of that treaty standard. Indirect expropriation is now defined. There is a definition that is akin to modern treaty practice, I should say, including a carve-out for non-discriminatory measures for the public good. Those should not constitute indirect expropriation unless exceptional circumstances warrant a different assessment. On MFN, it is now specified that ISDS provisions, dispute settlement provisions, as well as substantive law provisions from other treaties shall not be implemented. So the focus is really now on the actual treatment. In this connection, it was also decided to delete Article 16 of the ECT. The new provision on full protection and security clarifies that it only concerns physical security, not legal security. And last but not least, the umbrella clause is limited to contract breaches that are exercised through governmental authority. Moving on to ISDS, the discussions focused on transparency, security for costs, third-party funding, valuation of damages, and frivolous claims. I will start with the last topic, frivolous claims. Much inspiration was obviously taken from ECT, former arbitration rule 41 paragraph 5, and European treaty practice. So you basically have 2 objections. One, ECT inspired, one related to claims manifested without legal merit. The other one related to claims unfounded as a matter of law. The third-party funding obligations basically implement similar provisions as has been discussed in ECT. I'm aware of the time. That is obviously a limited resource for today, so I will perhaps move on to a topic that is of more interest in this room, that has been already touched upon by Daniela, and that is the issue of REO. REO stands for Regional Economic Integration Organization, and under this topic, there was a discussion to what extent it is desirable to clarify the scope of application of DCT among members of a REO that is in itself a contracting party to DCT. So in other words, it will really put on the table whether contracting parties of DCT want to clarify the long-standing issue of intra-EU application, and a decision was made to indeed do this. So the new ECT will contain a provision that clarifies that inter alia Article 26 on investor-state dispute settlement shall not apply between members of the European Union in their mutual relations under the ECT. That hopefully clarifies a long-standing controversial issue. And with this, I would also like to conclude my remarks. I hope the overview I provided was useful. Of course, I'm very happy to touch upon other topics in the Q&A, or obviously also to go into more details with the topics I raised in my presentation. So thank you very much.
Thank you very much, Lucas, for doing a fast-paced and close look into the negotiations themselves, but also the outcome, and finally doubling down the status of the dispute settlement as seen from the perspective of the modernization negotiations. Now, Nikos, I would like to ask you a question, launch for very brief answer on the following, which is, do you have any comments with respect to the notion of modernization? Is this an amendment to the treaty from your perspective, or what is it from your viewpoint now close to
Well, thanks, Jose Antonio, for inviting me again. We had last year a wonderful debate, and I hope we will have this here again. Well, I think in a way, what I find ironic is that, I mean, obviously, the negotiation objectives of the EU and the member states are or were not exactly the same as the other half, let's say 25 plus ECT contracting parties. I think that's really important to recognize, right? And that makes it, I think, very difficult in the sense that the EU, under pressure from parliaments, NGOs, et cetera, and also because it wanted to push its own, if you like, CETArization policy through and harmonize the ECT also in terms with its CETA project and CETA model. It had to amend, if you like, in a multilateral agreement, the treaty, but actually to a large extent related to the internal, if you like, plurilateral situation, right? So if you have to see, I think, this whole project, if you like, kind of like with two circles. You have the outer circle that relates to the multilateral part, covering all the elements that Lucas mentioned with regard to all ECT parties, right? Like, for instance, the narrow FET standard or the sustainable development chapter that is included, and the Paris Agreement elements, et cetera, the removal of the empty PO box companies as investor. I think that's all, applicable across the board. But then you have the plurilateral internal circle, right? Which applies then in particular, or has the addressee is the EU, right? And we should note in this context, it makes it more complicated that, for instance, Italy has left already the ECT a couple of years ago, right? So even within the circle of EU plus EU member states, you don't have even all of them on board, right? And of course you have, and I come to that later, you have the UK as well, being outside the circle largely, I would say, or completely, depending on where you are. So I think that makes it very complicated. So yes, you can say it's a treaty amendment, but if you like, it's a multiple treaty amendment relating to particular circles, particular addressees. And I think that makes it very complicated and also difficult because obviously the elephant in the room, and we come to that in a minute, is of course the whole issue about the cases, the ISDS provisions, et cetera, and you would like to make the easy comparison with the termination agreement with regard to the intra-EU bids, but that doesn't apply exactly because of this multilateral non-EU contracting parties to the ECT. So it's a very complicated amendment process that very much, I think, goes into the direction of a la carte amendment, depending on when you are. And I think that is probably also the new approach. We see that also with regard to the UNCITRAL Working Group 3, that we will see more kind of like opt-in, a la carte selection by different contracting parties depending on what they want, depending on where they are in their thinking and in their kind of like investment treaty practice reform status.
Thank you, Nikos. Well, well, I'll that notion of a la carte ECT, which I understand you're also extending to the negotiations group 3 of UNCITRAL is one to have in mind. Let's go into the notion of what is the geography, and by geography I mean the different groups of cases that can be identified following this modernization process when it enters into force, which hasn't happened yet. But what is the geography of those? And by that I mean, could you comment on cases that are ECT cases, that are past cases, possibly, and also present cases, and you have just a few minutes for doing that, about 4 or 5, and I know that it's not an easy job, but I know that you can do it.
Well, thanks, but I would like to start also for the purpose of understanding for our audience, because I was looking at the text. I think it's important to mention exactly what is written in the leaked text, because I think that's really important. When you look at the leaked text, and coming back to what I said previously, it is interesting to note that this provision, which is just one sentence saying for greater certainty, Article 7, 26, etc., shall not apply among the members of the EU. And obviously Article 26 is the ISDS provision. Now, interestingly, you find this in the new Article 24 under general exceptions. So it's a general exceptions article. So you don't find this, which I always think it would be the natural place, in Article 26 itself or in an annex. No, you find it in the general exceptions provision, which I find is quite interesting. And it's just this sentence, right? So, and that raises a host of questions, namely, apparently, and I mentioned already, if you like to make the comparison with the termination agreement, there seems to be no transitional period. There seems also to be no cutoff date specifically mentioned. So arguably, this can apply potentially retroactively, hopefully not, but obviously in the future, from the moment it enters into force. Let's say it will enter into force by the end of next year, for instance, or in 2024. But that already makes it very difficult. We do not have, like in the termination agreement, that it says the cutoff date is the Achmea judgment in March 2018, meaning, all the cases that have been concluded before the Achmea judgment, right, are done and will not be touched, and everything that has been initiated after the Achmea judgment will either be done through the facilitator system, or they are simply prohibited for the future, right? That was a very clear-cut kind of situation. Now, going back to the ECT, we don't have that, at least not in the leaked text. There might be some, hopefully, maybe some further declarations or explanations may be attached, but in the leaked text, I don't find it. So that raises the question. So when you have the old cases, so meaning cases that have been concluded before it enters into force, let's say 31st December next year. So arguably would say they would continue under the, I would call, ordinary rules. They would be concluded under the current ECT. Everything would be done under the normal situation. And arguably, they could be fully enforced and recognized. Well, here we start again, at least outside the EU. I'm not so sure if they could be still enforced and recognized inside the EU. We come to that in a minute because of the CGU judgments, right?
Let me pause you for 1 second and make
Yes.
make a brief question, and you don't have to answer it, but when you and I you don't have to answer it, because I think that it could linger in this space, alluding to your background here, as we can see, and put my sort of professor's hat. If someone came to me and said, well, there is no language in the treaty indicating that this general exception applies retroactively, or I would ask, is there explicit language indicating that this exception applies retroactively? And then then the answer would be, well, yes, there is, or there isn't. And depending on the answer, you'd say, well, you must then look into the general rules of or general principles of treaty law, the Vienna Convention on the Law of Treaties. So that I would stop there. We don't have the official text, but logic would go that route. Sorry for interjecting, and please go ahead, and be mindful that at the most you really have 3 minutes to sort of wrap up, and this will not be the last time.
No. There's so much to say. No, I mean, it's a very, but still, I would like to stick to this point that you mentioned, because it's hugely important, because it exactly talking about planets. This is about Venus versus Mars. Venus being the Earth, Venus being the EU, Mars being the rest of the world. And I think that's a problem. The problem is that if we look at the experience and the jurisprudence of the CGU, we see that the European Court has no problem to go retroactively and take away all the rights and positions. That's been done in Acmea, that's been done in all other cases, right? So from a European perspective, and that of course directly goes into the domestic courts of the EU member states that will have to recognize and enforce any of such awards, there is a clear danger that it would apply retroactively. Under public international law, and also I would say generally with regard to tribunals, you would clearly say, well, no, there are kind of like rights, legitimate expectations and rights that investors have on the basis of the current ECT, and from a rule of law perspective, that you would not take those rights away retroactively. But the reality is, within the EU, I'm not so sure about this. This would be my answer. But the more complicated issue are the ongoing cases. Danielle alluded to the numbers. There are a huge number of dozens of cases, ECT cases, both intra and extra ECT cases pending, and they are churning out all the time. We've seen a couple of other cases already. We have the Rockhopper case, we have the LSG case, we have more cases coming out, another case against Spain just a few days ago. So they are out there, but it doesn't really mean that you actually will be able to enforce and recognize it. Actually, if it comes to the moment that these proceedings are concluded after the entry into force of the ECT within the EU, and for the EU member states and the EU, I have serious doubts whether domestic courts in the EU member states would be allowed under the European Court to still recognize and enforce them, even if it's an exit award. I think that's really important, even if it's an exit award. And finally, well, for the new cases after entering into force of this revised ECT, I think for intra-ECT cases, it's arguably over. Although there is still the issue, and we might come to that later, and I stop here, about my idea about the analogous application of the sunset clause, kind of, as a rule of law, natural law principle. Anyway, thank you so much.
Thank you very much, Nikos. I know that it's very challenging to embrace the format and be able to identify answers in a structural manner in this format, but I think that you did a wonderful job. Maureen, you're mostly invited to make comments on the sort of geography of cases, the past, current, and future cases, as you so wish. And yeah.
Sure, happy to take that on. And I have to say that, I mean, to maybe go back to the beginning of sort of the overview of this entire process and the subject of our conversation, I really have to give credit to Lucas and the entire modernization project, because as I teach investment treaty arbitration and investment treaty law, I often find myself saying that, you know, the tribunals are confronted with interpreting the texts in front of them. And if you don't like where the tribunals are coming out with those texts, maybe we should have better texts. And I feel like the project that Lucas has undertaken with all of his colleagues has essentially ticked off kind of the wish list of all the better texts, right? The texts that solve these problems that have come up in the cases, and done it in a remarkably short time. So all the credit in the world for that. To get through a multilateral renegotiation process in 2 years, I would not have thought actually possible in many circumstances. So, and so what we're now thinking about, though, and the taxonomy that Nico set out, is what does this mean going forward, right? What does this mean for anybody who's holding a judgment in an ECT case, and in particular in an intra-EU ECT case? What does this mean for the parties that are still in the middle of litigating an ECT case as this transition happens? And then what does this mean going forward? And I think I generally agree with the taxonomy that Nikos has set out. We were joking before the panel began that for outsiders who are not in the EU and not fully steeped in let's say the primacy or the supremacy of the EU system, a lot of the discussion from Achmea on has just involved shaking your head and thinking, okay, let them do them, right? But it doesn't work that way, because I mean, we saw, you know, Comstoy, as Daniela pointed out, does not involve any EU parties, and yet it became the occasion for the CJEU to take a position on the applicability of the ECT to intra-EU disputes, and to bring into question the ability to enforce even a non-intra-EU award in the EU. And that, I think, was well, it's only the most recent of many surprises for those of us watching from the outside of the EU space. And I think maybe we simply have to accept Nikos's rule that, you know, the EU system is going to take this approach, apply it retroactively, even if 64 tribunals have disagreed with that notion. Daniela conveniently gave us the statistics. I usually say that the track record so far is dozens to one, but Daniela pointed out that it's actually 64 to 1. So my thought is that tribunals in pending cases are likely to continue to take that approach and not accept the idea of retroactive application of these transitional provisions, whether it's Achmea Comstoy or the transition in the EU ECT mechanism itself. But going forward, I think we're certainly going to see enforcement pushed to the United States for those pending cases and for the concluded ones. So we'll see enforcement pushed to the United States, the UK, or any place else that will take them outside the EU. And then I think, you know, we have to look ahead and think, well, for investors who are imagining a future in which they might someday need to bring a case under the ECT, maybe they should be structuring themselves through the UK, through Turkey, through other ECT member states, so as to just not run into this, you know, vacuum in the EU space, and to potentially get the benefit of the treaties. I was also thinking, as Daniela was speaking about the curiosity of Italy's situation, they withdrew from the ECT and may now find themselves actually worse off, right? Because they've got the full application of the sunset clause for 20 years. do they get the benefit of all these amended and much improved investment treaty provisions, or do the does Italy have to live with defending disputes under the old rules? And certainly, I think we'll start to see fun things play out there. So I think it's going to be interesting to see the cases react, see the tribunals react, and over the longer term, see investors react. Jose Antonio, you're mute. The curse of Zoom.
Thank you so much, and apologies for that. I was saying thank you, and I wanted to ask you, Nikos emphasized on the notion of retroactivity in some of the possibly rulings by the CJEU, as well as in some of the and I believe that you also meant, Nikos, by some of the European Commission's decisions in terms of applications of its views on ECT and also its views on intra VITs. How does the notion of retroactivity apply or would be potentially be interpreted in U.S. courts in other systems of the world? And I admit that I hadn't thought about that question until now. So for all purposes, this is not a preconceived question, but I find it very, very interesting given the weight that the Supreme Court in the U.S. and appeals courts have given to the rule of law. And that of course is a question for you, Maureen. Yeah.
Right. Well, I mean, we know in the Mikula case that the district court was not impressed with the retroactive application, although it focused on retroactivity vis-a-vis Romania's entry into the EU, as opposed to the retroactivity of ACME itself, I guess. I mean, the U.S. courts are not the place where I want to spend, where I want everything to turn on having to make arguments under the Vienna Convention, right? I mean, any national court where you're facing an enforcement procedure is going to be a difficult place to start explaining international law principles of retroactivity or not, or frankly explaining the EU system or not. And what we've seen actually is that many of the US courts have simply said, oh, let's wait and see, right? We understand this is being litigated. We understand that there are tribunals considering this issue. We understand that there are courts in the EU considering this issue. We'll wait. Unfortunately, they're now going to be at the point where they have to stop waiting and actually decide. And so I think we don't yet know exactly how the US courts are going to deal with this sort of set of very EU-centric rules and decisions and changes. And I think we could get sort of a complicated spaghetti for a bit as courts take different approaches to trying to sort out how to understand what is happening on the other side of the pond. But they will have to start confronting it now because they had cheerfully pushed it off and issued a bunch of stays in a number of the cases. And they're now going to get confronted with it's time to decide.
Thank you very much. And yes, I mean, indeed, time is often a real concern in the U.S. Court system. So it's I think that I like to view it as unlike other systems where it could be decades before things get decided. At some stage, courts believe that goes hand in hand with potential what we like to call in international law sort of denial of justice, but they don't say it in those terms. Now, Nikos, do you want to share your views on enforcement in the UK or other non-EU jurisdictions? Yes.
Yes, thanks. Well, I think just while Marine was speaking, I think at the end of the day, you probably have to make also a distinction between exit awards and non-exit awards. I think probably, I hope, arguably, that exit awards based on the exit convention should be or should provide a stronger legal basis for, at least that was the idea, for rubber stamping an exit award before domestic courts, right? At least outside the EU. So I think on the exit award side, you are probably fine. And I think I reread the UK Supreme Court decision in Mikola a few days ago on this point, and I think they made a very good point here in my perspective, and a very balanced public international law argument saying, well, you know, the UK is an exit treaty party, contracting party. Romania and Sweden are, and we have the obligations towards all exit parties, right? And therefore, those international obligations should be fulfilled and should proceed. Now, of course, we have gotten this new concept of a bundle of bilateral relations that was thrown out there recently in the CGU. Was it Mikola or Kumstroy decision? Can't remember. So if you have the view that maybe the exit convention is simply a bundle of bilateral obligations, you get again into this multi-faceted plurilateral situation that I mentioned before, potentially, right? So I think that's one thing. So I think on the exit award side, I would feel more comfortable, and I would hope that all those 150 plus exit contracting parties would follow through. On the non-exit awards, I think we run into more problems, because here clearly the ordre public exception through the New York Convention opens the door wide. Well, opens the door wide open. I'm not sure if you can say that in any event. So there is a possibility here, I think, that tribunals, domestic courts might go in different directions in different jurisdictions. So for instance, I'm thinking of Switzerland, right? Swiss courts being in the geographical vicinity of Luxembourg, right, and Europe, and also being pressured by the EU in to completely different other matters, international law matters, cooperation matters, I could imagine that maybe Swiss courts might be more open towards saying, well, you know, we understand the EU law, we understand the CGU, and therefore, you know, from an ordre public perspective, we might really kind of like accept that what's going on, right? I'm not saying this is going to happen, but I could imagine that this could be a direction. I don't think that would happen probably in the UK. But of course, there are other many jurisdictions, I don't know, let's say Singapore, other countries that are a bit farther away from the EU, and they might not be so inclined to follow it. So in any event, but focusing on the UK, I think, as Marine also said, I think the UK would be a really interesting place to enforce it. Obviously, still there is still a little bit the issue to what extent maybe EU law and CGU jurisprudence still might be applicable. You know, we don't know exactly, you know, it depends really on the timing. And I want to come back to that. I think it really, depends when you initiated your case and when did you get your award. I think when you are really, if you like, in the phase prior to the outcome of the ECT negotiations, I think you are already really better protected, if you like, by your legitimate expectations and by the kind of like rule of law in terms of non-retroactivity. But I think the moment, let's say you start now a case, right? You initiate today a case, or maybe just before the summer break, let's say 1st August or so, I am not so sure, there might be arguments made saying, well, you're reading GAR, you're reading ER Reporter, you know that things are going on there. So you cannot legitimately claim that you didn't know that potentially things will drastically change for you, right? This could be, I really not hope that this is going to happen, but this could be an argument that can be made and could be accepted maybe by some domestic court somewhere. So I think the timing here is really crucial, and the same I think applies with regard, when did you get your award? When was it issued, right? And the closer you get to the tipping point, right, in terms of when this thing enters into force or when it was out there, the less likely or the more problems you will probably get. But this is again something of a hunch, and we must wait what comes out. But I don't know, maybe Lucas, I don't know, have you discussed this internally or with other, I don't know, it would be interesting to open this up because I wasn't in the room. I'm sure that somebody must have raised these kind of issues.
Anyway, that's a fair question. Let me ask each of you to give your sense of how does the potential outcome of the modernization process and granted we don't know how the text will be because we only have a leaked text, but let's assume for a second that it's somehow it's not that different from what was leaked. I mean, but we know that it may be completely different, but it is possible that it has some similarities to what was leaked. And let's think about whether both investors within the EU and outside of the EU within the framework of ECT will of course have effects of that. Our investors, where are they left in terms of consequences, and are they better off? Are they not? I mean, and this involves many variables, including transitioning into new energies, living out at some stage fossil fuels, etc. So I will ask each one to sort of reflect and give me an answer. Each one no more than 2 minutes, because we have to somehow be respectful with time with our audience. So let's start with Lucas, and then we go Daniela, Marine, and then Nikos.
Thank you very much. First of all, thanks to all for this fascinating conversation. Of course, issues like premise of EU law, retroactivity have been very close to my professional heart the last couple of years. So I felt tempted to intervene again, but I will refrain from it in the interest of time. So concluding observation from my side, I think when assessing the whole package, one needs to be mindful that the political landscape has changed. The current ECT is a too heavy burden for states. That is blatantly clear. Of course, the feelings towards the current ECT may be different, but I think there is a general recognition among contracting parties that something needed to be changed. And as far as I see it, the text that has been not agreed upon, but that has been the outcome of the negotiation is or could be a sustainable way forward to maintain a system of invest protection and the energy sector. I'm obviously a bit biased, but I'm inclined to think that it's a positive package for users of the system, for investors, as well as for states, because basically it increases legal certainty. The old ECT is vague. It caused inconsistent interpretation, inconsistent case law, as was explained by Daniela, And ticking off the wish list, as described by Marin, helps both sides. You know as a state much better the scope of the regulatory space that is accorded to you by the treaty. And of course, from the investor perspective, it is easier to calculate the chances for success in litigation, which is of course important because it has financial implications. Whether one likes the different the distinction between so-called green investments and fossil fuel investments, that's perhaps a matter of political choice. I would simply note that I don't know any field of law that has not been changed in light of Paris Agreement obligations. So one may not like it, but perhaps it may be a preview of what is probably happening in the future in treaty practice.
Thank you, Lucas. Daniela?
So I think the modernization had to happen just because, as Lucas mentioned, the political landscape changed. The priorities of states are different from the priorities that were at the beginning of the 90s when the ECT was negotiated and then entered into force, when no one was talking about the renewables and energy transition, decarbonization didn't exist. That being said, the fact that we need it, and I think the treaty drafters, they learned some lessons from these interpretations of the tribunal. So we have, because Nikos was mentioning the text, we have the right to regulate, which is quite an innovation for a treaty these days, especially the new treaties, they have it, but not in the old treaties, you don't see that. Then you have the sustainability clause, which in my opinion, it's a need if you want to be in line with the Paris Agreement and with what the European Union is championing, decarbonization. On the dispute settlement, I don't necessarily agree with the view, but that's just my my personal view. And I think that will affect. And I tend to agree with Nikos that there is a lot of uncertainty, and with Marin about what's happening. What's the moment zero? Are we going retroactively? Are we applying AFMIA? So there is, as I mentioned in my presentation, there are challenges and opportunities and room to be creative, but also there is a pressure from the outside world saying that the EU and the member states should leave the ECT. I don't see it necessarily happening, especially with the political landscape that's happening now in the EU. Again, that's my personal view. But there was a note from the IMF yesterday published saying that in the energy transition and investment in green and sustainable finance, being part of the ECT as it is now, as we are speaking, that doesn't stimulate the energy transition rather than continuing to invest in fossil fuels. So yeah, there is no perfect treaty. So that's the beauty and the problem in the same moment. Thank you.
Or possibly treaties. Marin?
Well, so I mean, it is easy to look at the text and look at what's happening to the ECT as a whole and think, to answer the question you posed about, are investors better off? It is easy to look at it and say, okay, well, they've lost this and they've lost that, or they've lost the ability to bring claims related to fossil fuels under certain, in certain different time periods. But I suppose that if we take a step back from that analysis, you do have the point that Lucas made, which is you've got some more clarity about which claims will or won't fly, whether it's about public debt or whether it's about judicial decisions or things like that. You now know that certain things are off the table. So there's more clarity in the provisions. So you don't waste the legal fees on pursuing a claim that won't succeed. And then there's the sort of the really meta question that I think was posed by the title of a blog post that Nikos wrote, which is this about saving the ECT itself, right? I mean, was it, as Daniela said, necessary in order to preserve the ECT as a functional entity going forward and to stop what might have otherwise been a flow of states leaving the ECT. Now, there may still be states leaving the ECT. So did we succeed at that? I don't know. We won't know yet. For a bit yet. As we know, Poland is now saying that it's going to leave or making noises about leaving. Spain and the Netherlands may still feel grumpy about the whole process. But if it does indeed, quote unquote, save the ECT, then the investors are better off, right? So I think we have to sort of think about the question at multiple levels of utility.
Thank you. Thank you, Maureen, and now Nikos, and that, undoubtedly, the world has changed, and many of your comments also made me think about the situation in Ukraine, giving the invasion, etc. But I want, I don't want to launch, yet another sort of whole discussion, but that is also a very practical and pragmatic question in the sense of, would there be an ECT, and how important is there that there is one? Nikos, just final comments, 2 minutes, and then we'll move into the thanking part of our panel.
Yes. Well, I would like to end positively. You will not believe me, but I really would like to end positively. But I find it very difficult. As I wrote in previous blogs, I find it still very ironic, and I still don't understand it, why the EU and the member states essentially disconnected from the ECT, whereas they achieved essentially all their objectives that were mentioned, right? In terms of modernizing it, ceterizing it. I find this a pity. I find it a bad signal, to be honest. And even more so, we haven't raised it that, but I was just checking. There is also a new Article 17 bis now, which also explicitly excludes subsidies from the scope of the ECT, as I read it, at least in terms of ISDS provisions. And that, of course, I think makes it difficult in terms of renewable energy investments. That's how I see it. But in any event, what I see is that I think there will be a shift to the extent that there will be commercial arbitration coming up as much as possible. I think there will be restructuring as much as possible. And at the end of the day, well, yeah, the ECT will obviously lose some of its importance because the sheer number of cases are going to go down significantly. And that is, of course, what was the main aim of this whole operation, obviously, from a state perspective. And that may be good because it may save some taxpayer money, but I still would caution because, as I said, it creates a plurilateral situation where some countries are still in the ECT, some countries are partially in the ECT, and some are not at all anymore in the ECT. And I don't think that is a good development, because it actually goes into the issue of, in the direction of fragmentation, right? And that is exactly what we try to avoid, for instance, in the UNCITRAL Working Group 3, and trying to harmonize things. So I find it still kind of schizophrenic how this, from an EU perspective, EU member states perspective, this is done. I would have hoped that, having achieved 99% of all your objectives, except maybe in the ISDS side, that the EU and the member states should have stayed in the ECT fully and fully committed there, and actually supported, because we need the investments in the renewable energy sector. So time will tell. Hopefully I'm wrong, but personally, I think at the end of the day, investors, also because of the substantive standards which have been tightened up, will not be better off. That's my conclusion, but we will see.
Thank you very much, Nikos. Thank you very, and I would like, I saw some nonverbal language from Lucas. If you want, if you have any comments, I don't want to steal those from the audience. Just 30 seconds to say, if not, that's also absolutely fine. Good, excellent, good. Well, thank you very, very much to each one of you, and in the order that I see you on my screen. Maureen, thank you so much for the beautiful view of Washington D.C. now that the sun has come out, and the spatial view from Washington D.C. Daniela, which happens to be the same spatial view that Nikos has from Europe. And of course, Lucas, thank you very much. It has been a pleasure and an honor to be with you. I had a lot of fun by asking questions that I wanted to ask, and some that I didn't know that I was going to ask. Frankly, it was great. This recording will be up at some stage for people to learn, view, etc. And now we might move into I think 2 breakout rooms possibly. We will only be there for a few minutes, perhaps 5 or 8 minutes, for people to relax a little bit. There's no recording there. We don't have to speak about the ECT, but we're also not bound not to do so. So thank you for your time, for your organization. This has been a truly great panel, and also for the preparation that I know you did for this panel. So next panel will be on next 2 panels will be on tax, and the other one on space law. So stay tuned.
Thank you so much. It was a great pleasure. Thank you all.